I have a judicious mind and a judicious responsibility. I am the chairperson of the Rules Committee of Parliament, which is charged with the responsibility of investigating any issue or allegations of misbehavior. Given that role, I cannot participate in being an accuser because these are potential matters that may come to my committee, and I have a judicious mind. I can't therefore be the one accusing members. Instead, members appear before my committee. So I cannot be party to a process of now being an accuser.
Honorable, yes, we are certain that you as a chair, you cannot be party to signing, party to accusing and everything around that.
Absolutely.
But we expect that probably you could give guidance on how both parties could be able to move.
No. The guidance I'll give is actually when the matter comes on the floor, because the House would expect to have an opinion from me as the chairperson of the Rules Committee. That's number one. Issues of law, I can give a general comment as a lawyer, but not on the substance, because I cannot be party to the people signing.
Would be glad to get that guidance as a lawyer.
Particular one.
How these individuals, especially those that are supposed to go to court, but also those that are supposed to register the matter. Okay, just to inform you, there are individuals, some who are legislators who have run to courts of law, challenging a process here which is to censure the 4 commissioners of Parliament.
Well, first of all, I didn't know about it. You are just informing me. But matters which are in court, according to our rules, and you know I'm now the custodian of the rules of Parliament of Parliament. When a matter is in court, and if it is in the opinion of the presiding officer, who is the speaker, and the presiding officer, whether speaker or deputy speaker, if in his opinion will prejudice the proceedings in court, then any other process becomes sub judice. It is entrenched in our rule, the rule on sub judice. So if it is true there are people who have gone to court and the opinion of the presiding officer, that matter will prejudice on the floor the process in court, then it becomes sub judice. It can't be debated on the floor. That's what our rules say.
But also we would certainly get a share of your knowledge. If these matters, if one of the matters was probably registered in the House earlier than it could have been registered in the courts of law, is there provision of how that can be handled legally? No, there is no provision. The rule is clear. It says if a matter is in court, it does not talk about before, after, or during. But if the matter is now in court, then the House's hands are tied. It becomes restricted, except if it is in the opinion of the presiding officer, not prejudicial to the case in court. But if it is, then it becomes prejudice and cannot be heard on the floor. And the reasons are clear for everybody to see. You can't have 2 parallel processes. There is a process going on in Parliament and another one going in court. One undermines the other. And we are independent arms of government, but we should work in tandem. You don't use one process to undermine a process in another arm of government.